Today's Teamsters case once again raises questions over the use and possible abuse of the Racketeer Influenced and Corrupt Organizations Act. Known as RICO, the law was established to give the government power to go after mobsters. But the law has been applied far more broadly and has touched off a rising tide of criticism among defense lawyers and civil libertarians. We'll take up that controversy in a moment, but first, Kwame Holman has a background report.
Would it be fair to say that you went back to prison that you'd be a dead man?
Congress passed the Racketeer Influenced and Corrupt Organizations Act, RICO, in 1970, after several years of investigating organized crime. At these 1963 Senate hearings, chaired by Senator John McClellan, mobster Joseph Valachi shocked the Congress with an insider's perspective on organized crimes, loan sharking, extortion, kidnapping, and murder.
You honestly believe that they were under orders from Genovese to kill you there in prison?
Yes, 100%, Senator.
100%.
4 years after the hearings, a presidential commission called for legislation to stop racketeers from infiltrating legitimate businesses. Under the old laws, the government could only prosecute individuals for their individual crimes. The commission recommended a law that would allow the government to prosecute organizations for a pattern of criminal activities. Congress responded with RICO. Those who drafted RICO did not limit it to organized crime, nor did they spell out how far prosecutors could go in applying it. Robert Blakey was counsel to Senator McClellan's committee and helped draft the law.
Congress debated specifically whether the statute should be limited to organized crime, for example, in the mafia sense, and decided since the problems were characteristic of all similar prosecutions, the statute should be written to fit all similar prosecutions, not limited to organized crime, for example, in the sense of the mafia.
RICO could be used to prosecute any individual or organization if certain conditions were met. First, those charged had to be engaged in racketeering activity, such as murder, kidnapping, extortion, or mail, wire, or securities fraud. Second, they had to have committed at least 2 racketeering acts within 10 years. Conviction meant stiff penalties. Fines of up to $250,000 for an individual, up to $500,000 for an organization, or double the profits from the racketeering activity. Sentences of up to life in prison. And forfeiture of all profits and monetary interests in the racketeering organization. Since 1983, the Justice Department has averaged more than 100 RICO prosecutions a year, among them the successful prosecution of this white supremacist group charged with setting fire to a Jewish center and a gay church. Some of the most important RICO prosecutions were brought in New York City by U.S. Attorney Rudolph Giuliani.
The government's complaint alleges that organized crime has deprived union members of their rights through a pattern of racketeering.
Giuliani used RICO to battle organized crime. Anthony Salerno, boss of the Genovese crime family, and 4 other crime family heads were convicted as members of the Commission, a ruling council that regulated mob activities.
The ability to bring the entire commission under the RICO statute means now that the major muscle for organized criminal enterprises in the United States has now been brought to the bar of justice.
Giuliani also used RICO to go after corrupt officials. Former Congressman Mario Biaggi was convicted for using the WedTech Corporation to bribe government officials to win military contracts. Former Bronx Democratic Party leader Stanley Friedman was convicted of turning the New York Parking Violations Bureau into a racketeering enterprise for personal profit. When Giuliani used RICO to prosecute corrupt politicians and gangsters, no one thought about it twice. It was another matter when he aimed RICO and its powerful forfeiture provision at legitimate Wall Street firms. RICO stirred controversy because it allowed prosecutors before trial to freeze assets allegedly derived from criminal activities. Last year, Drexel Burnham Lambert, a New York securities firm, agreed to plead guilty to securities fraud and to accept a $650 million settlement rather than face a RICO indictment. Princeton Newport, an investment banking firm, actually was indicted. Company lawyers say the threat of forfeiting millions of dollars in profits caused creditor confidence to erode and forced them to go out of business before they could go on trial. The two Wall Street cases prompted charges that Giuliani had taken RICO prosecutions too far.
That's too draconian a weapon to be utilized in what are normal garden variety criminal securities prosecutions. I think they should be treated the way they've historically been treated. People should be indicted for violating the securities laws, and either they win or they lose. And then the punishment meted out, as opposed to a form of quasi-punishment before trial.
Robert Blakey disagrees.
I see, for example, nothing inappropriate with a serious forfeiture being imposed on a major securities firm where the underlying set of facts indicates that the firm has stolen, in effect, hundreds of millions of dollars from people. A forfeiture in that amount seems to me to be not draconian, but poetic and wholly appropriate.
When Congress designed RICO, it armed the law with stiff civil as well as criminal penalties to encourage individuals victimized by organized crime to sue the racketeers. If the victim wins, the award is triple the normal damages, lawyers' fees, and court costs. But civil RICO did not work the way Congress envisioned. Private attorneys began filing RICO suits in all sorts of commercial disputes, having nothing to do with criminal organizations. IBM, for example, sued Hitachi for theft of computer secrets and won a settlement of more than $200 million. Suffolk County, New York, won a $23 million suit against the Long Island Lighting Company for fraudulent rate increases, but a federal judge recently dismissed the case, saying it didn't belong in federal court.
The range of misuse of civil RICO runs from the absurdity of where the FBI, in conducting a sting operation, was labeled a racketeer and forced to defend itself, to Cadillac dealers who have failed to honor their warranties, to laser printer manufacturers who have been labeled racketeer because the printer didn't print as fast as it ought to Hasidic Jews arguing over the succession of who the rabbi should be in a synagogue.
The American Bar Association estimates that only 9% of RICO's civil suits involve the kind of professional criminal activity that caused Congress to write the law. Lower courts have tried to throw out frivolous RICO suits, but in 1985, the Supreme Court ruled that only Congress could restrict RICO.
In practical terms, it meant that civil plaintiffs had a green light to go to the federal courts with generally ordinary civil disputes and know that they were not going to be thrown out on that basis. And therefore, civil litigation was going to increase, and it has.
An American Bar Association survey shows that private attorneys used RICO in only 9 civil cases prior to 1980. In the past 2.5 years, the number of cases has jumped to more than 2,700. Congress has tried to pass legislation amending the statute, but without success.
Joining us now to take up this issue is the head of the New York State Task Force on Organized Crime, Ron Goldstock. Mr. Goldstock also teaches a course in the uses of RICO at Cornell University, where he joins us from tonight. Alan Dershowitz is a professor of law at Harvard University. He joins us from public station WGBH in Boston, Massachusetts. And starting with you, Alan Dershowitz, do you think that RICO is out of control?
Oh, I think it's been out of control for a half dozen years at least now. What happened is Congress gave prosecutors a weapon that was suited to going after one particular crime, that is racketeer influence in legitimate businesses. It was a very, very important weapon, and nobody disputes that. The problems of organized crime getting into legitimate businesses was not capable of really being solved through the usual laws, although the conspiracy laws gave them plenty of weapons to do it. But today it's being used against abortion protesters. It's being used against bookstores. It proves the old adage, if you give the prosecutor a weapon, he will use it to the limits of his ability. To plea bargain.
But what's wrong with that? I mean, what's wrong with using it against abortion protesters, stockbrokers, bookstores, as you indicated?
Well, the primary thing that's wrong is that it's false advertising. It's mislabeling. These are not racketeers. Call them what you want. A group of well-intentioned men and women who are trying to close down an abortion clinic are not racketeers. People who run a bookstore are not racketeers. people who try to use the mail to defraud in stock cases. They're bad, they're criminals, but they're not racketeers. What it does is it undercuts the important work of going after real racketeers. The use of the phrase racketeer has become so diluted that today it's meaningless, and it ought not to be meaningless. We know a real racketeer when we see him. We know what organized crime is. We know what extortion and murder is. But to use these RICO statutes, as they've been used over the last few years, primarily against plain, ordinary, garden variety criminals who've had the bad fortune to do it twice over the past 10 years, then to use the incredibly vindictive civil remedies against them and to prevent them from getting lawyers by seizing their property in advance, to deny them really the right to a trial, because when you get a RICO prosecution, it's likely to go on weeks and months. You get a record that you can't appeal from. The jury doesn't understand it. It's confusing. They've heard the prosecutor call him a racketeer. That's the end of the case.
Okay, before we get too confusing with too long a laundry list, which I hope to get back to some of in just a moment, let me go to Mr. Goldstock. Is RICO false advertising and undercutting the whole ability of law enforcement to go after the mob?
No, I think the history of RICO has shown that it's been incredibly effective against the mob in legitimate industries, against the mob at running their own syndicates. It has also been effective in a wide variety of cases, as Professor Dershowitz points out.
But what about his argument that it's been misapplied in more cases than not?
Well, it may be misapplied in some cases, but that's true with any statute. Whether it be a criminal statute or whether it be a statute which provides for civil relief, there are always going to be abuses. But the problem there is for the courts to fashion remedies to those abuses, not to get rid of RICO.
Mr. Dershowitz?
Well, I think we have to go back to the drawing board. I don't want to get rid of RICO. I just want to apply it only to organized crime. The government should have to prove this is an organized crime, real racketeering activity. Because you know what happens otherwise? If you get a case against Drexel Burnham, and Drexel Burnham is accused of being a racketeer, people out there really think that there's organized crime involvement in Drexel Burnham. They're just misled. Now, nobody, not the government, not anybody else, believes that.
All right, let me just ask Mr. Goldstock to respond to that. Mr.
Goldstock? I think that's such a naive position. If in fact what Professor Dershowitz is complaining about is the use of the term racketeer, I'd be perfectly willing to get rid of that term. If you want to call it a pattern of criminal activity rather than racketeering activity, if you want to call the crime enterprise corruption rather than racketeering, that's fine. But the basis of the crime, to look at organizations rather than individuals, to look at remedial aspects rather than just putting people in prison, seems to me to be the important part and the part that's worked quite well.
And you would say that the application to Drexel Burnham is appropriate under the circumstances?
If you want to call 3 people who are collecting bets on a street corner racketeers and not a major corporation which, according to the allegations, has fleeced hundreds and thousands of people of millions of dollars, it seems to me that that is inappropriate. If they act like racketeers, they ought to be called racketeers, and the remedies ought to be appropriate.
Arose by any other name, Mr. Dershowitz?
No, but they're not acting like racketeers. By a racketeer, we mean somebody who uses the threat of violence and extortion, the threat of murder to achieve their goals. That's why 3 people collecting bets on a corner, if they're backed by organized crime, are indeed racketeers, because if you don't pay your bet, you're going to get your knees broken. Drexel Burnham doesn't break people's knees. I agree with you. Let's start by getting rid of the phrase racketeering. The next step should be, let's draft new statutes for each individual problem.
Let's get a statute
passed for commercial activity, a statute passed for the kind of activities that Drexel Burnham was involved in, and another statute passed for protesters against abortion clinics and bookstores.
All right, Mr. Goldstock, what would be wrong with that?
Well, the fact is that this statute works perfectly well in all of those cases. If what is the major problem is the name of the statute and the use of pattern of racketeering activity, we can eliminate that. But I haven't seen any argument which suggests that the statute itself, the use of the enterprise for committing the crimes forming the basis of the complaint, the use of treble damages, the use of forfeiture is inappropriate. In all those cases, it does seem to me to be appropriate. And where there are minor abuses, and there may be some in particular cases, then the courts can handle that quite easily.
But
the courts have said they won't handle that. The courts have said we're throwing the ball back to Congress.
But
the Supreme Court of the United States has said we won't do it.
But hasn't the Congress in the first instance, the Congress itself didn't limit RICO, and in the second instance, the courts have refused to limit RICO, saying that if there is a what did it call, a loophole or a defect in the statute, Congress should fix it.
And Congress doesn't have the guts to take on a statute that uses the phrase racketeering. That's the problem. In fact, it's getting worse. States all over the country are now passing baby RICO laws, which are applying well beyond what Congress had in mind. Let me give you the one example of bookstore. I think it was in Virginia. 2 bookstores which sold primarily constitutionally protected material. Somebody walked into the 2 bookstores on the same day and bought 1 magazine in one store, 1 magazine in another store. That made them into a racketeer, influence, and corrupt organization because there were 2. That is the pattern of activity. Although it was done on one day, it doesn't matter. That brought the statute of limitations back 10 years instead of 5 years. It accused them of being racketeers. It allowed the government to seize all of the material in the bookstores. The Supreme Court said that was going too far. You can only seize all the material in the bookstore after you've proved that they're racketeers. It's just fighting a fly with a nuclear weapon, and we shouldn't be doing that in a society. The fact that it works effectively is not the only issue in a democratic society. It is overkill.
Mr. Goldstock? Fighting a fly?
No, it's not fighting a fly. I think it's inappropriately used in the bookstore context, but the fact is that I think all statutes directed towards obscenity and pornography are misapplied. Without the use of RICO, a prosecutor could use those statutes to take books out of a bookstore and to forfeit the property. It's not just RICO that does it.
Mr. Goldstock, let me ask you on the specific point that Mr. Dershowitz raised earlier and that was raised in the tape piece, this issue of this triple damages being applied to people found guilty under the RICO statute. I mean, do you feel that that's excessive?
These are in private rights of action. It's the same treble damages that are applied in antitrust cases. And if it's appropriate there, if punitive damages are appropriate in cases in which you're involved with criminal acts, with intentional torts, then it seems to me to be appropriate in this case. This is essentially liquidating punitive damages to twice actual damages. I don't think that is the major problem. The fact is that crime has gotten much more complex, and law is government's response to these social problems. And it designed RICO with the complexity of crime in mind. And it is useful not only in dealing with racketeers, but in all these other cases. And the reason that the reason that the legislature has not changed is because they haven't been misapplied to any great extent, and no one can point to any great travesties of justice. I can find great travesties with respect to most criminal acts. I can find them with a great number of private causes of action.
Just briefly,
we see abuses all the time.
What's your response to the other criticism raised by Mr. Dershowitz and also in the tape piece that the law tramples on the rights of individuals by seizing their property before they've been indicted and before, or at least before they've gone to trial?
Any time when an individual is suing somebody else and seeking damages, they want to make sure that ultimately, if they prevail, they can attach the assets, have the assets available. And so they go through a legal device called attachment or freezing the assets, and they have to show, in order to do that, that they're likely to prevail at trial, that otherwise the assets would be dissipated, and that they're in a balancing test that there is not an undue burden on the defendant. And that's precisely the test that I use in the RICO context. It is no different in RICO than any other civil action. Indeed, in the Marcos case, where all of the Marcos assets were frozen, they were done not under the RICO statute with which he was being accused, but also under a pendant state claim.
Right.
So it's not that RICO does this. That is the way the law operates. And we may have problems with law in complex cases and mega trials, but it's not the RICO problem.
Right. Mr. Dershowitz, what do you think needs to be done at this point, and do you think it's doable?
I think it's doable. I think we have to understand that one statute can't cover all the evils of this country. This statute was passed many years ago, before crime became as complicated as we now hear it has become, and correctly so. We need new statutes. We need a statute for investment banking if that's perceived as a problem. We need a new statute and a separate statute for protest activities. We need another one for bookstores. Every statute has to be tailor-made to the particular problem. Alexander Hamilton once said that the civilization is measured by how thick its criminal code is, not how thin. These people are being very lazy, taking an old statute, applying it to every new problem that's come up. It's now being applied to environmental polluters. It's being applied to people who use the mails. We need different statutes for different evils.
Mr. Goldstock, you don't agree with that. And do you think that it's not doable to change it? You think RICO will prevail?
No, I think Congress may change it. I hope they don't. I think it has been used very effectively in a wide variety of cases, but I have no objection with Professor Dershowitz. If he would like to develop new statutes aimed at particular types of problems and find that that works better than RICO, I have no problem in those particular areas of recalling RICO and allowing the other statutes to work. But in terms of laziness, it is people who have not developed those statutes to deal with those areas, who have not been able to deal with corruption in labor unions for 40 years without RICO. And it seems to me that now, having RICO working, the burden is on the other foot to show that something is better.
All right. Well, we have a little bit of agreement here. So on that note, we'll end it. Mr. Goldstock and Mr. Dershowitz, thank you both for being with us.
Thank you.